After I finished the sentence that day, the room went so still I could hear a bailiff turn his wedding ring against the wood rail with his thumb. I want to tell you about her before I tell you about the case, because by the time most people hear about cases like this one, the person at the center of it has already become a number in a file. She was not a number to me. She never was. By the time I spoke that sentence, I already knew there was one thing I could not give back. I could not give back the child she had already named Mateo. I want you to hold on to that for the next few minutes, because everything I'm about to tell you, every photograph, every transcript page, every word I said from that bench, points back to that one thing, and none of it brings him back. Subscribe, not for me. For the reason I am telling this, some stories need more people to carry them than were in the room when they happened. Subscribe and help me carry this one. The first time Elena Ramirez walked into my courtroom, she moved like someone whose body had learned pain and had not yet been told it was allowed to forget. She was 29 years old. Her left hand stayed near the edge of counsel table for a moment before she sat, as if she wanted to make sure the world beneath her was real and steady. I noticed that before I noticed anything else. Later, during one of the longer breaks, she took the cap off a bottle of water, set it down, turned the bottle until the label faced away from her, and lined it up exactly with the edge of a yellow legal pad. No one else in the room would have cared about that. I did. Small acts of order tell me a great deal about what a person is doing to stay inside themselves when the room around them is asking for more than they have. The defendant was Marcus Bell. He was 34. He drove a delivery van for Pine Route Logistics, and the first thing I noticed about him was where his attention went when he thought nobody was marking it. It did not go to Elena. It did not go to the exhibits. It went to the clock, the courtroom door, his lawyer's legal pad, and once very briefly to his own hands. There was one thing about him I found genuinely human. On the second day of testimony, while counsel argued over a foundation issue at sidebar, he opened his wallet under the table and looked at a child's drawing folded into fourths. He closed it fast when the deputy shifted near him. It made the situation worse, not better, because it told me he did not live at a distance from the meaning of a child. He knew. The incident happened on Tuesday, September 12, 2023, at 5:17 p.m. at the intersection of West Hawthorne Avenue and Grant Street in Cedar Glen. Elena was driving home from a prenatal appointment. She was 32 weeks and 4 days pregnant. Her doctor had told her that afternoon that the baby's heartbeat was strong, that the swelling in her ankles was normal, and that she should come back in 1 week. Marcus Bell was driving east on Hawthorne in a Pine Route Logistics van. The speed limit there is 25 miles per hour. The data from the van showed 41. The traffic camera showed the light red for 3.8 seconds before he entered the intersection. His phone records showed he opened a dispatcher message 11 seconds before impact. On the stand, he said, "I only looked down for a second." Elena had the green light. She was turning left. When his van hit the driver's side of her car, it pushed her across one lane and into the curb by the pharmacy on the corner. The first officer on scene said her window had burst inward, and the inside of the car smelled like antifreeze and airbag dust. A bystander named Naomi Pierce said Elena kept trying to unbuckle her seatbelt even after someone had already cut it away. At 2:11 a.m. the next morning at St. Agnes Medical Center, after an emergency surgery and hours of bleeding they could not stop in time, her son was delivered without life. His name was Mateo Ramirez. I read that name first on a hospital record, then on a death certificate. Then later I heard his mother say it out loud. It was not the same each time. What crossed my desk first was not grief. It was paper, a charging affidavit, a crash reconstruction report, a toxicology report that came back clean, 32 printed pages of phone extraction data, a medical packet clipped with a pink cover sheet that said fetal demise in block letters, so plain and blunt it made the rest of the page look ashamed of itself. There is a legal detail most people do not know. In my state, when a pregnancy is far enough along, the law asks for proof in weeks and measurements before it asks what the loss meant. It wants the gestational age, the heartbeat records, the doctor's findings, the timing of the placental abruption. I understand why the law works that way. I also know what it looks like when a human life gets translated into boxes that must be checked before anyone can say what happened in honest words. The moment in the process that made me pause came before trial, during a pre-trial motion over wording. Defense counsel wanted one count described only as unlawful termination of pregnancy. The prosecution wanted the child's name included where the statute allowed it. We argued about nouns for 19 minutes. That is part of the work. It is also one of the moments when the gap between what the law can name and what happened sits in the open long enough for everyone to see it. The morning testimony began. I watched them enter from the bench. Elena came in through the right side door with her attorney and her mother. From where I sat, I could see something almost no one else could see. Before she looked at the witness stand, before she looked at the prosecution table, she looked at the empty space between the two tables, the place where people stand to be sworn. She looked at it as if she had already walked there in her mind too many times. Marcus came in from the back holding his suit jacket closed with 2 fingers near the middle button. He did not look up at me first. He looked toward the gallery where his older brother gave him one small nod. Then he sat. From my angle, I could see him slide his phone from his pocket and surrender it to his lawyer without being asked a second time. That detail stayed with me longer than I expected. There were 3 moments in that courtroom where the room went completely quiet. Not the kind of quiet that happens between questions, the kind that settles when something true has just entered the room and nobody knows what to do with it yet. I am going to tell you about all 3 of them because by the time I reached the 3rd one, I understood that silence can carry as much fact as testimony if you know what put it there. I want to ask you to subscribe before I go further, and I want you to know that I do not ask lightly. What comes next in this story is the part that cost me the most to say out loud. Subscribe, stay with it. Silence. One came on the first afternoon. Elena had already answered the usual questions, her address, her job at Maple Street Elementary, how long she had been pregnant, whether she knew the intersection, whether she remembered the impact. She was doing what so many people do on the stand, keeping her voice neat, giving the room the version of pain that sounds usable. Then the prosecutor asked her what she remembered in the hospital after surgery. Elena looked down at her hands, not for long, maybe 2 seconds. When she looked back up, she said, "I woke up and I lost my baby." That was all. Not louder than her other answers, not slower, just that sentence, with the word "my" landing a half step after the rest of it. The room went quiet for 7 full seconds. I know because I looked at the digital clock beneath the seal on the wall and because I did not trust my own sense of time in that moment. The court reporter's fingers lifted off the machine. One juror, number 6, lowered his eyes to the wood rail in front of him. The person who finally broke the silence was me. I said very softly, "Take your time, Ms. Ramirez." It was the only sentence available that did not feel like theft. After silence 1, I understood something I had not fully understood from the file. Before that moment, I knew a collision had caused a death. After that moment, I understood that Elena was not testifying about an event alone. She was testifying about waking into a different life than the one she had gone to sleep expecting. The law can hold those things together, but only barely. The first wave of evidence was clean and plain. Traffic camera footage, phone data, speed analysis, medical testimony from Dr. Hina Patel, who explained placental abruption in terms simple enough for a jury and hard enough for a mother to hear while sitting 20 feet away. She said the force of the crash caused the placenta to separate from the uterine wall. She said time mattered. She said by the time surgery began, the loss was already in motion. A paramedic named Joel Sanderson gave the kind of testimony juries often forget because it is not dramatic. I did not forget it. He said, "She kept asking if anybody had heard him move." I wrote that down in my own hand, not because it changed the charge, because it changed the room. The defense tried at first to narrow everything. Yes, Marcus had looked at his phone, they said, but only briefly. Yes, he entered on red, but he had been working under dispatch pressure and a delivery deadline. Yes, Elena lost the child, but there had been swelling earlier in pregnancy, and medicine is not math. They were doing the work defense counsel is required to do. I listened carefully, because listening carefully is part of the job, even when the facts are already forming a shape you do not like. There is one sentence I can say about my role and no more. I could decide consequence. I could not return her son. The prosecution called Naomi Pierce, the woman who had been standing outside the pharmacy waiting for a ride. She wore a blue grocery store uniform and kept apologizing for not remembering exact times. People do that. They apologize for being human when the room is full of paper that remembers better than they do. She said Elena reached for her stomach first. Then she looked at me like I was supposed to know something. I wrote that down too. In the middle of that testimony, a memory from my own life came back with no warning, a hallway light left on after midnight. My wife standing in the nursery of our first apartment, one hand on the crib rail, the other holding a yellow sleeper no bigger than a folded dish towel, the window unit humming, the whole room smelling faintly of baby soap and fresh paint. I do not need to explain why that memory came then. It came and it stood beside the case until the end. Subscribe. I will say it plainly. I owe it to her to keep telling this story. You subscribing is how her story reaches past this video. Subscribe and stay. By the time the defense put on its case, the facts were mostly fixed. What remained was meaning, and meaning is where trials often become harder, not easier. Marcus Bell did not deny he was using his phone. He said the message came from dispatch and that drivers were expected to respond fast. He said the light cycle at Hawthorne and Grant was short. He said, that corner is confusing if you're trying to make your window. I listened to that sentence and heard more than he meant to say. Then he said the entitled thing I had been waiting to see whether he would say out loud. I said I was sorry. I don't know what else they want from me. He said it during cross-examination when the prosecutor pressed him on why he had never once asked through counsel how Elena's recovery was going. There are sentences people say because they think the room will hear fatigue. Sometimes what the room hears instead is the size of a self. Later, quieter, he said, it was an accident. He said it almost gently, as if gentleness could change the shape of a choice after the fact. I do not use the word accident lightly from the bench. Sometimes it fits. Sometimes it hides the doorway people walked through while still pretending no door was there. The quote that stayed with me most came near the end of his testimony. His lawyer asked him if he had ever meant to hurt anyone that day. Marcus looked toward the jury and said, I never thought one glance at my phone could count as a choice. I wrote it down. I looked at it for a long time before I moved on to the next page. That was the road to Silence 2. It did not arrive with grief the way Silence 1 did. It arrived with recognition. After Marcus finished his last answer, after defense counsel said, no further questions, the courtroom went quiet for 4 seconds, maybe 5. It was a drier quiet. Less like a room holding pain, and more like a room realizing it had just heard the hinge on which the whole case turned. What changed for me in Silence 2 was simple. Before that moment, I was still measuring negligence in degrees. After that moment, I understood that Marcus had been telling himself a story in which choices only become choices if they end well. That is not how the law works. It is not how life works either. The prosecution's rebuttal witness was Marcus's dispatcher, Dana Holcomb. She brought login records that showed his company did not require an immediate response while the vehicle was moving. The message could have been answered at the next stop. Dana did not sound angry. She sounded tired. She said, we trained them to pull over. That sentence did not need help from anyone in the room. Subscribe. I am not going to make a case for it. You are already in this story. Subscribe and let me finish it. When I returned with my verdict notes, I had already spent hours with the record, the exhibits, and the law that governed the counts before me. I had made this decision carefully. I had made it knowing that careful decisions and right decisions are not always the same thing, and believing that in this case, they were. Before I spoke, the air in the room felt thin in the specific way it does when everyone is braced against a sentence that has not been said yet. I found Marcus Bell guilty on the count of aggravated vehicular assault, guilty on the count of unlawful use of a handheld device while operating a commercial vehicle, and guilty on the count charging the unlawful termination of a viable pregnancy. I spoke each count separately. I did not rush any of them. When I finished, Elena did not cry. She closed her eyes once and pressed her thumbnail into the side of her index finger until the skin went white. I have not told you what I ordered yet. I am about to. Subscribe before I do, not because it is dramatic, but because I want to explain every part of it, and I want you to be here for the explanation. Subscribe now. At sentencing, I began with custody because some harms require the law to speak first in the language of restraint. I said, I am ordering you to serve 30 months in state custody, followed by 5 years of supervised probation. Then I explained why. I said that a red light ignored at 41 miles per hour with a work phone in hand was not a lapse too small for confinement. I said public safety means very little if it is only spoken after nothing irreversible has happened. I am also ordering a financial penalty of $25,000 to the Cedar Glen Pregnancy and Infant Loss Fund, payable in installments set by probation if necessary. I chose that cause because the harm done here did not end at impact. It ran through a hospital room, a funeral home, a recovery bed, and the long months after when people stop asking how you are because they want life to look normal again. Money does not heal that. It can still be pointed toward the place where care is waiting for the next family. I suspended both your commercial driver's license and your personal driver's license for 8 years. I said that plainly. I wanted the room to hear what that meant. It means 8 years in which you do not get to sit behind a wheel and tell yourself one glance is too small to matter. It means the privilege you used carelessly is removed for long enough that the removal can do the teaching your judgment did not. I ordered 600 hours of community service with the Cedar Glen Safe Roads Coalition and the Trauma Recovery Transport Unit at St. Agnes Medical Center. Not office hours, not paper sorting in a back room where no one would ever see what these cases leave behind. I wanted him in places where recovery has wheels, braces, quiet hallways, and names on clipboards. I wanted service tied to the nature of the harm, not to a generic idea of being sorry. I ordered a public and personal act as a condition of probation. Marcus Bell was required to write a letter to Elena Ramirez not to ask forgiveness, not to describe his own suffering, but to state in full sentences what he did, what choices he made, and what those choices cost. He was also required to read a separate statement aloud at 3 driver education classes in Cedar Glen and once at Pine Route Logistics in front of active drivers, dispatchers, and supervisors. I specified the audience because some truths should be heard by the exact people most likely to repeat the mistake. And there was one more thing. I ordered full restitution for Elena's uncovered medical bills, pelvic rehabilitation, grief counseling for 3 years, lost wages during recovery, and the cost of Mateo Ramirez's grave marker, with the inscription chosen by Elena and no one else. I saved that for last because it was the part of the sentence closest to the shape of the actual loss. The law cannot restore a child. It can, at minimum, refuse to leave his mother alone with the bills that followed his death. Then I spoke directly to Marcus, and I remember those words because I chose them slowly. I said, "You struck more than a vehicle. You struck a body carrying 32 weeks and 4 days of hope, preparation, and expectation. You caused a broken pelvis, surgical trauma, months of physical recovery, and the death of a child whose name was already spoken in that family's home." I said, "To your family, I will say only this. They did not choose what you chose, and nothing I do from this bench should pretend otherwise." Then I said, "Your position required you to carry freight with care, answer pressure with judgment, and treat the rules of the road as if other people's lives were inside them because they are. You chose otherwise." And the last thing I said to him was not about him at all. I said, "Mateo Ramirez was here, and this court will speak as if that is true." That is when Silence 3 arrived in full. If Silence 1 was grief entering the room and Silence 2 was recognition entering the room, Silence 3 was permanence. After I finished the last line of the sentence, nobody moved for 6 seconds. I know because the deputy nearest the door had started to shift his stance before I spoke, and when I stopped speaking, he froze with one hand still hooked near his belt. I could hear the air vent above the jury box and nothing else. Marcus stared at the defense table. Elena looked straight ahead at me, not with gratitude and not with relief. Her mother's hand had found her shoulder at some point during sentencing and was still there. The silence finally broke when someone in the back row let out one short, surprised sob and tried to swallow the rest of it back down. Thank you for staying with this. I mean it in the specific way you mean something when it costs you something to say. Subscribe if you have not yet. You already know why you are still here. I stayed on the bench while the room began to empty. Judges do that for many reasons. One of them is simple. You do not rush a room that has just had something permanent spoken inside it. The first person I watched clearly was Elena's mother. She stood before Elena did, leaned close and said, "Baby, breathe now." Then she took Elena's bag from the floor with both hands, like even that small weight should not belong to her daughter first. Marcus's lawyer put a hand near his elbow but did not touch him. The deputy waited. The clerk began stacking files in the careful, quiet way clerks do when they understand more than people think they do. Elena rose slowly, turned once toward the prosecution table, and then toward the aisle. As she passed behind counsel table, close enough that I could hear her over the shuffle of papers, she said to her sister, "I only wanted someone to say he was here. I have said that sentence back to myself more than once since the case closed. When I finally stood, the room was almost empty. What I noticed was the witness stand. The microphone light was off, the chair was pushed in neatly, and a paper cup still sat beneath it where Elena had left it half full. The appeal was filed, as I expected it would be. It went to the Court of Appeals for the 2nd District. The defense challenged the custody term, the public statement requirement, and the restitution order. On March 3, 2025, that court affirmed the sentence in full. In plain language, they said the sentence stayed within the law because each part of it was tied directly to the harm, the risk created, and the work of repair. The process took just under 11 months. I expected the appeal. I still read the ruling twice before I set it down. There is one thing I learned later that I have kept with me. On October 14, 2025, according to the probation compliance report, Marcus Bell stood in room 204 of Cedar Glen High School and read his statement to a driver education class of 92 students. When he reached Mateo's name, he stopped for 3 seconds, looked down, and then said it again before he finished the paragraph. The question I still ask is not whether the sentence was lawful. It was. It is not even whether it was fair, though I believed then and believe now that it was. The question I still ask is this: what do we owe the truth once it has entered a room and changed everyone who heard it? I have thought about that longer than I expected to. This case taught me something I do not say often because it sounds too tidy if spoken carelessly. Grief and clarity are not opposites. In my experience, one tends to produce the other if you sit with it long enough. Not quickly, not cleanly, but eventually. The people who come into court carrying loss often know what matters before anyone with a file ever does. If you are someone who has sat in a room trying to say what happened to you in a voice calm enough to be believed, I recognize that look on Elena's face the moment she took the stand. It is the look of a person doing 2 jobs at once, telling the truth and managing other people's comfort while telling it. If that is a burden, I want to say something exact. You are not required to make your pain easy to hear for it to be real. And if you are someone who has ever looked at a phone while driving, answered pressure with speed, or told yourself that one small shortcut does not count because nothing bad happened last time, the question I wanted to ask from the bench was never legal. It was this: how small does a choice feel to you right before it enters somebody else's body? Here is the one specific thing I will offer. Put the phone where your hands cannot reach it before the key turns. Make that choice early while it is still cheap. There are other people I want to speak for. Other cases where someone needed a voice in that room and what they received instead was procedure. Subscribe and I will tell you those stories when I am ready to tell them. This was the first one I was ready for. I want to end where I began. Elena, the name first, not the case first, not the statute first, not the van, the speed, the red light, or the sentence. Her name, because that is still the right order. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I'm asking. Subscribe and stay. And if you leave a comment, leave the kind people right when they understand they are standing in a room with other people who have carried hard things too.